Good evening, everyone. I am CA Indrajit Kaur Bamra, moderator of this webinar, and we are delighted to welcome you all in the webinar being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICI. It is my pleasure to be a moderator in Know Your Law Series 64th webinar on Digital Personal Data Protection Act and Professional Opportunities for CAs. It is being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICI. In a short while, we will start this webinar. I would like to apprise you about CCLA and NPO committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. And one of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. So today we have our eminent speaker who will talk on Digital Personal Data Protection Act and professional opportunities for CAs in this webinar, and we hope that the same shall be useful to the members. So before inviting sir, I would like to, and I'm thrilled to introduce our distinguished speaker, CA Harpreet Singh, a multifaceted professional with qualification as a chartered accountant, MBA, company secretary, and cost and management accountant. He has earned his degrees from prestigious institutions, including an MBA from Power Business School in Spain and an MDP from IIM Raipur. Currently, Sir is serving as the Associate Vice President at the Royal Bank of Scotland, and Sir leads a team of 5 CAs and MBAs. His extensive experience includes significant roles at Yes Bank and delivering over 30 sessions in internal audit. As a prolific speaker, Sir has conducted numerous seminars for ICI, ICSI, ICMAI, and other prestigious forums. His expertise span business law, valuations, banking, and digital personal data protection. He is also an active contributor to national journals and a former editor-in-chief at ICA Merit. So please join me in welcoming CA Harpreet Singh. Welcome, sir.
Thank you. Thank you so much, madam. Should I start now, ma'am?
Yes, sir.
Perfect. Let me share my screen. Let me know once you're able to see. Okay. Screen. Okay. So today's topic is Digital Personal Data Protection Act. So yes, was just settling down. So yes, it is a very, very interesting topic, DPDP Act. Why it is interesting? Because the predecessor of DPDP Act is GDPR, General Data Protection Act, and the same regulations are going to be part of the Indian legal system. And when GDPR came outside India in Eurozone, and when these laws came in other countries of the world, the impact was humongous. There were a lot of penalties, huge penalties, and the importance of this topic, this whole law, is very much because today we are in the age where we are on the internet all of the time. We are having our smartphones where apps are taking a lot of permissions. to access photo galleries, to access videos, to have a lot of information, whether it is your mobile phone number, your email ID, your address, and a lot of things, right? So the importance of this law is very much in that aspect. And this law was passed in August 2023. But till now, this law is not given effect to. Why? Because of the huge impact that this law is going to have. Because there are a number of companies, IT companies, or the other companies, and we are going to talk about on whom this law is going to be applicable, whether it is going to be on the huge firms, huge companies, or the smaller ones also. So the impact is huge. That's why these companies are requesting government, and there are a lot of discussions which are going around to defer to the time it is possible. But there's no time left when this law is going to be effective, because this law is part of the 100-day agenda of the new government. So this law is definitely going to come in a very, very short span of time. And since it is an important law, it is going to impact a lot of people, a lot of companies, a lot of course, the whole of the India, including we professionals. That is why there is a requirement to understand what this law is and what is going to be the impact on us, on our clients, on the big companies, and how we can get prepared for it. And of course, the topic also includes exploring professional opportunities. So what are the new opportunities? Are there some new areas of practice which we can develop in this? So we are going to discuss all of this, right? So this is, of course, the agenda. There are certain key questions that we are going to think about, that we are going to talk about. Okay, when I listen to DPDP, Digital Personal Data Protection Act, what are the questions that come in my mind? So we are going to start our session with that. Then we are going to see, okay, what is the background, why this law has come? And of course, I have given some of the background to you. Then the applicability, on whom this law is going to be applicable, because these are the ones, these are the transactions that are going to be in the ambit, and the persons on whom this law is going to be applicable are the ones who are going to be our clients. Whether they are now our clients, then of course a new area of business is there. And if they are not our clients, then a new area of practice, a new client is going to come. Yeah. Yeah. There are certain definitions that there are in this law. Of course, there are very few which we are going to discuss. And then there is a consent. We are going to discuss about that. Legitimate use, how we are going to use the data legitimately, that's another thing. So then the data fiduciary. Who is data fiduciary? So he is the one upon whom this whole of law is going to be applicable, and he is going to be our client. So data fiduciary is a very important person. And what are the tips to keep the data secure? So we are going to discuss about that also. Who is SDF, significant data fiduciary? So this significant data fiduciary is going to be the first fiduciary, first person on whom this law is going to be applicable. Exemption, what are the exemptions? Some people are also exempt. And then what are the penalties? And why this law is so much important, why there is a lot of emphasis on this law, is because of the penalties. There are a huge penalties, and we are going to discuss what are those and how those penalties are going to be levied, and whether those penalties are only for the namesake. If I am saying 500 crore, 200 crore, is that amount only for namesake? Is that amount only just to threaten, or the huge penalties can be levied, or the penalties are already levied outside India to that extent? So we are going to discuss that. And then of course the opportunities for chartered accountant. What are those opportunities, right? So this law is very, very simple. It is hard, and this small law, of course, the rules are going to be notified soon, but this small law is having such a huge impact, such a big impact, and we are going to see that. And it is a very simple law. There are only 4 items, 4 definitions. So, digital personal data protection. There are 3 parties. data fiduciary, data principal, and data processor. And then there are two ways in which the data can be used. One is legitimate use that we just read, and then consent, and then there is one penalty clause. So, but that one penalty clause is having a huge impact. So 4321, and this whole law, this whole presentation finishes. So, but yes, the impact is huge. And then the focus of the act is digital personal data and protection. And the definition, each of this word is very, very important. And we are going to see how, just by playing with the meaning, just by having a debate, just by having a new argument, you can cover something in this act, and something can be taken out of this, out of the purview of this act. So yes, the focus is digital personal data and protection. What are these? Now, to start with, what are the key questions which come to our mind when we think about this law? Okay, this is DPDP, digital personal data protection. What does this law include? So if you see, data is everything, whether it is a photo in your phone, whether it is a video which is taken by a CCTV camera outside your house, everything is data, right? So my phone number, my email, everything is data. So how this new law is going to change our lives? Are the cameras which are installed outside our houses, do we have to deinstall those cameras? Are the cameras which are installed by Delhi government or any government for law and order, do they have to deinstall, and do they have to take those cameras back, and then those cameras are not? Sorry, there was a call in between. So these are some of the things. Or the cameras which are in our offices, or for example, we are working in corporate, or we are having our own office. So the cameras which are in offices, do we have to install those cameras? And then we are having in our office a lot of files in which the customer data is there. So do we have to send those files back, send those documents back, because the data protection law is coming, and we cannot keep the data? Or do we have to make some changes in the way in which we do? Or there are some bots which are there, and these bots use a lot of data. There is AI which is coming, and ICI has recently launched its AI portal also, ICI AI. So are these going to be impacted when this new law is going to come? So we are going to have answers to all these questions, right? Okay, now what is the background? How this law came into picture? So yes, one thing is, of course, this law was already there in some Western countries, and that's how this law came. And actually, there was a petition in the Supreme Court, and the Supreme Court declared right to privacy also as a fundamental right. So there was a controversy, there was a case which went around the Aadhaar, where we are sharing our biometric data with the people, with the government, right? And so there was a question whether right to privacy should be a right or not. So yes, government was one of the parties, and the Supreme Court ordered that yes, right to privacy is also going to be a fundamental right now. And then thereafter, there were certain committees formed, there was a law made, then that law was scrapped. A new law was made later on, and then in August 2023, of course, the law got passed from Lok Sabha, Rajya Sabha, and then August 2023, 11 August to be precise, President of India signed the bill and it became an act. So basically, this was the background. But yes, from 11 August 2023, today it's 4th July 2024, but still this law is not yet effective. So yes, there is something which is going on in the background. Of course, there were elections also, but yes, because the impact is huge, and we are going to see how, right? And yes, the background is the international background. GDPR came into picture, and I was one of the people in the team. So when it came for our bank, so I work for RBS, as ma'am has mentioned, and when at that point of time this GDPR came, the same hue and cry we were having in our offices also, that yes, we have to implement a new law. What to do now, right? So there were a lot of teams made, and in the team there were a lot of experts. And because the impact is so huge, as a bank, you understand that bank has a fairly good system in place when it comes to information system, when it comes to data management. But even then we had to do a lot of changes in the way we work, a lot of changes in the data management practices, a lot of things, a lot of people to understand what this law is, what are those changes that we have to make. So yes, at that point of time also there was the same human cry, there was the same huge impact, since it is a multinational bank that I work in. And then of course UK had their separate law later on. So there are countries, Europe, USA, Brazil, South Africa, Bahrain, Philippines, Canada, UK, all have their data protection law. So now the question arises, these countries have a data protection law. Were we not having any data protection law which protect our data? We get a lot of calls from these companies who are giving us credit cards, who are giving us loans, or anything, opening bank account, having insurance. So there are a lot of calls that we get in a day. And meanwhile, I was taking the session, I got a call in between. So of course, this shows that there is no law. But my friend, this is wrong. There is a law, already a law in India, but that law is a very limited law. That law is having a very limited scope. And with this DPDP Act, the scope of the protection of data, the scope of the whole law is going to increase manifold. And we are going to understand what was covered in Information Technology Act, and now what is going to be covered in DPDP. So the area of protection has increased manifold. And of course, 11 August, it got its assent and rules and effective date yet to be notified. Now this picture in front of your screen, highest GDPR fines by country. So you can see there are a lot of countries where 2.8 billion euro there's a fine. So Ireland, UK, there are a lot, Sweden, there are a lot of countries where the fines are very, very huge. So this is not something which we are trying to exaggerate. This is going to be the reality. In India also, when there are going to be huge fines, of course, there are huge penalties which are already defined. And the question is that those penalties are going to be used, are going to be applied. Why? Because we have same precedent in the Western countries. That's why. And if you see all the top companies, whether you take Meta, Facebook, TikTok, Amazon, WhatsApp, and not only these IT companies, the apps that we are using, H&M, Marriott is a hotel chain, British Airways, Clearview AI is of course Criteo. So these are the companies, not only IT companies, not only the companies which are having their apps, but the companies who are having any kind of business. So if you are an airline, you are taking mobile phone number, you are taking email ID, you are taking address. So you are definitely taking data. And take any example, as a chartered accountant, we are taking a lot of information, a lot of data from our clients. So we know the crucial aspects also. We know about their income, we know their bank statement, their balances, everything we know, right? So we have collected a lot of data also. So you take any businesses take data for their running. And we will see in the coming slides that yes, there is one rule or one section where the board, so we will be discussing about that, the board can actually order that yes, from tomorrow you cannot use any data. And what it effectively means that your company, your business is going to be closed. So why now these huge fines were put? Simply because some app, Facebook, WhatsApp, was not actually allowing its user to untick these extra data that they are taking. So they are taking a lot of data about your spending habits. They are taking a lot of data, which apps or which websites you actually visit. So uh, Amazon and Meta was actually not allowing them to untick that if you want to use our app, if you want to use our platform, you have to give access to all of these. Just like in our phone, we see that yes, whenever there is an app, so it take access to all the photographs, also your contact list, also everything, right? So these companies were fine for this. So you should give an option, and we are going to see how those options are now being given in the foreign countries after GDPR and these laws coming, and how these things are going to change in India as well. British Airways. So company had a simple bug that yes, all the people who were just coming on their website, so the data was copying to another website of some hackers. And in H&M, what happened was the data was not leaked to any persons outside. Only internally, one employee was able to access the health records of another employee. So there was a bug, and I could access my colleague's health statement. Okay, he is having diabetes, or he is having what kind of disease. And after that, what company did was company paid some compensation to all the employees, that yes, it was a settlement, that yes, don't do any complaint, don't do anything, but yes, till that time the damage was already done. Even after paying the compensation, the company was hugely fined 35.25 million euros. So this is the impact of this law, and these are the huge fines, and then the same are going to be repeated in our country also. Now, what is the applicability? On whom this law is going to be applicable? Of course, I would like you to think about the questions that are coming to your mind, note it down, and of course, at the end of the session, there will be dedicated Q&A session. So just take a pen and paper, just note down what your question is, because your questions are going to ultimately enrich this content. So yes, keep an eye. Then what is the applicability? On what transactions this is going to be applicable? So first point is any processing within territory of India. Now, what is processing? Processing simply means use. So if you are using the data in the territory of India, in the country, then this law is going to be applicable on that. How you can use? You are using mobile phone number to call someone, you are using email ID to email someone. Whenever you are accessing, whenever you are using it, processing means simply use, then this law is going to be applicable. Okay, when you use in digital form, but the data is in digital form. If you are using any data which is in on the paper, so or you are keeping that data on paper, probably this law is not applicable, because it is saying if you are using the data and it is kept in digital form, or in non-digital form and digitized subsequently. So the moment you save the number in your phone, the moment you put it in Excel sheet, the moment you put it in any digital form, any digitized form, then this law would start applying, right? So you are using that data in the territory of India, and it is in digital form or digitized subsequently. Okay. Now, there are some people who are saying, okay, this condition is there when I am calling someone from India, right? I am using that number, that phone number in India, and I'm calling someone that, yes, please buy the insurance. Now, what will I do? I will take help of the Sri Lankan people. I will take help of Nepal people. We will have our call centers there, and then this law is not going to be applicable. But the second condition is any processing if it is in connection with data principle within territory of India. So the people to whom you are calling are in India, then also it is going to be applicable. So it is in connection with the data principal. Data principal is the person whose data you are using, whose phone number you are using. So basically, I am the data principal because my phone number, my email ID, my address, my height, my weight data you are using for something, or my spending habits you are using. So you are having a use in India, or no matter wherever you are using, that use is in connection with the people in India, then this law is going to be applicable, right? Now, this is the applicability. But are there certain exceptions also? Are there certain areas where the law is not going to be applicable? So yes, there is a non-applicability clause also when you are using data of an individual for personal or domestic purpose. So if you are using that data for personal purpose, you are calling someone for your personal purpose and not for business, then this law is not going to be applicable, right? If you are calling someone for selling the insurance, of course, it is not your personal purpose, it is your business or profession purpose, then this law is going to be applicable, otherwise not. Okay. So what about the cameras which are installed outside my house? So yes, if you are keeping that video, that audio, that anything for your personal purpose and you are not circulating it anywhere, you're just having it for the security, then this law is not going to be applicable. So if you are having cameras installed outside your house, then this law is not going to be applying to you. So you can keep using that. Now, what about the government? They have installed the cameras at various places. Would those be covered in this personal or domestic purpose? Definitely not. Now we will see, is there any clause for that also? So yes, we are going to see that. Next thing is, if you have made that data publicly available. It is made publicly available by the data principal himself. So I am the data principal. It is my data, my phone number, my email ID. I have put it on Google. I have put it on Just Dial, anywhere, right? So it is publicly made available by myself. And then when I have made it publicly available, anyone can access it. Anyone can call using that number. So this law is not going to be applicable. So the next thing is, of course, if you don't want to receive those calls, you have to remove it from the public domain, right? Okay. So if the influencer in social media tells about, okay, I like to eat in this restaurant, I am buying this car, I am using this phone, I am using this mic, then he is making publicly available his information that yes, these are my spending habits, these are my likes. So anyone can reach him that yes, okay, this is our restaurant, right? Of course, if they are using his number, his phone number, again, there are certain components. One is using his number, another is using his spending habits, eating habits. This is also data. So if both the data are publicly made available, then of course, this law is not going to cover that. But yes, if you are having a personal account which is not made public, and there you are telling someone something that yes, I like to eat this, that, you are telling your friends only, and then this information cannot be used. So the act is going to be applicable. Now we have focus of the act, digital personal data and protection, these four items. How it is going to be covered? So what is data? So data means any information, any fact, any concept, my opinion, my instruction, which is capable of interpretation or processing. So basically anything which I can understand. Simple, as simple as that. So it covers any information. But when it comes to personal data, so it is because it is digital personal data, right? So personal data. Personal means relating to any individual. Now the companies, if there is any data relating to company, if there is any data relating to any charitable trust, any data relating to artificial judicial person or partnership, anything, they are not party to this law. They are not going to enjoy the benefits of this act, right? So it is personal data, it is relating to an individual who is identifiable by such data. Now, there's a lot of debate on this particular word, identifiable by or in relation to such data. So we will discuss that. And it is very inclusive. So any and every data. So whether it is your height, your video, your audio, your photograph, it is numerical data, or you want to keep phone number in graphical form, 879, yeah, even then, even then you are going to be covered. So you cannot outsmart this law because it has clearly defined everything, right? And whether it is your name, your identification number, any your membership number, that also is personal data. Location, your location. And I have a very good case about the location data I'll discuss. IP address, cookies, and whether it is physical, physiological, genetic, mental, economic, cultural, social, any data about you is going to be covered in this. Whether it is direct, whether it is indirect identifier, I am able to identify you with that data, then you are going to be covered in this. It is going to be covered in the definition of personal data. How? So for example, if you know my name is Harpreet Singh. This, you are not able to identify me till now, right? There are a lot of Harpreet Singhs in the world. I tell you, okay, Harpreet Singh from India. Still, you are not able to find me because in India there are a lot of Harpreet Singh. I tell you, Harpreet Singh from Meerut. Still, you are not able to identify me because there are a lot of Harpreets in Meerut. Then I tell you, Harpreet Singh, CA in Meerut. Then you are able to identify me because there is only one, or there are probably two. Then there are huge chances that you get to me, you reach me, right? So this is example of identifiable, right? So basically, there are debates which are going around this, but yes, if you want to understand, so any data about the person. Okay. Now, the data can be personal, non-personal, that we understood, right? Personal means individual related, and the focus of the act is that only. Now, this personal data is having two types. Regular personal data, my name, my phone number, my email ID, my height, my weight, these kind of data about me, or the sensitive personal data. Now, what is sensitive personal data? Sensitive personal data is sensitive. We hide that. So, our passwords, our bank account details, credit card, debit card details, present and past health records. So, we keep the health records very safe, right? It is not disclosed. Sexual orientation or biometric data. So these are the sensitive personal data, and for this there was already Law Information Technology Act 2000 and SPDI rules. These were already there. But what was not covered was regular personal data. So sensitive personal data was already covered. Regular personal data was not covered, and then this law is going to apply on regular personal data and also sensitive personal data. So it is going to cover everything. Now, what about the IT Act? What about these rules? These are going to be scrapped. So yes, in the Act itself, in the DPDP Act itself, it is mentioned that yes, we are going to omit these sections of the IT Act. And of course, there are some other omissions of RTI Act on which there has been a lot of debate. But yes, we will discuss that. Okay, now we have discussed the definitions. Now, what are the parties? There are three parties. We understood that. 4, 3, 2, 1. Data principal, data fiduciary, and third one is data processor. Now, who is data principal? So, data principal is the hero of this act. He is the person, and very important, she is the person, because in this law, the words are used she or her everywhere. So, this is a unique law in that sense also, right? So, data principal is the person who is the hero of this law, because for data principle only, for its protection only, this whole law is made, this whole act is made. So data principle is going to be the focus of this act. Data fiduciary is the person who is going to have the obligation, all the liabilities, all the obligation, all the penalties, not all, but yes, 99% of the penalties are going to be on the data fiduciary. So data fiduciary is going to be our client. Data fiduciary is the person who is using that data, who is getting that information from data principal. So data fiduciary, if you want to understand, you go to a hotel, they take your Aadhaar card, they take your email ID, phone number. So in this case, you are data principal because it is your data. And the hotel is data fiduciary because it is taking your data. And then it is the responsibility of the hotel to maintain all the security so that your data is not disclosed anywhere. And if it is disclosed, if they sell your data, then they are going to be penalized. Or if, yes, we are going to discuss what's going to happen, right? And then data processor. Third person is data processor. Who is data processor? For example, you go to amazon.com, you see a phone, you see a laptop, and then you just click on buy, you enter your email ID, your phone number, your address, your name, because you want that laptop to your home. Now, what Amazon does is Amazon gives it to its reseller, or for example, Amazon is selling itself. Then what it will do, it will pack the laptop and then it will hand it over to a courier boy. And what it will hand over to courier company is one, your laptop, second, your name, your phone number, and your address. Why? Because that person will call you on the phone and ask you where's your home. With the address, he will reach your home and then he will hand it over to you. So in this case, the company is not only handing over the product, but also your data. So in this case, Amazon, of course, has taken data from you. You are data principal, Amazon is data fiduciary, and that courier company becomes data processor. So data processor is the one who is using data on behalf of, on instruction of data fiduciary. These are the definitions. Of course, data principal, data subject, and we know that in case of child, it is parent or guardian, lawful guardian, and disabled, it is lawful guardian, and it is also called data subject in some of the laws. Now, data processor, data fiduciary, we have understood. Now, we have done 4, 3. Now it is time to go to 2. We understood these parties. Now, how are these going to use the data? We are going to understand that. And there are 2 ways in which the data can be used. What are 2 ways? Number 1, have your consent. So I ask you, can I use your data? Can I call you and give you the promotional messages? Can I email you what are the offers which are going on? So I get your consent. Second is the legitimate use. It is legal use. Now, what are these things? And in the consent thing, there is an opportunity. There is business profession opportunity. We are going to discuss that. This is going to unfold. Okay. Now, what is consent? Consent means your acceptance. You say yes, then I will use. Now, what this consent is going to be? I can't show you gun and then you say yes. It should be free. You should not be forced to give consent in any way. It should be specific. I am consenting that you use my data for having the promotional messages. And you have to mention what kind of promotional messages. Promotion about your products, promotion about travel, promotion about services, or what. You have to be specific. So the consent needs to be free, it has to be specific and informed. I am not going to take your signature. I'm not going to take your consent on anything that you don't understand. And we will see there are some conditions that, yes, if someone want to have, so consent is nothing but you are going to send an email, and on email, for example, you are taking consent, or you are having going to have a piece of paper, and then that consent agreement or the consent paper or the email, designing that, including what and what not, this is also going to be part of your role, right? So, of course, we know the law, we have read the law. Now, what clauses should we include there? How much free, how much specific we have to be, right? So we have to mention, we are the ones who know. Then informed. Informed means if I cannot understand English, you are sending the email to me in English. I don't know what you're saying, what you have written. So basically, there's a requirement that yes, if I want it to be in Hindi or in any of the 27, 28 languages, then you have to provide me in these languages, whether it is Telugu, whether it is Tamil, or any Punjabi, Gujarati, any language you want. The company, the data fiduciary, has to provide that form, that consent letter, that email in that language only, and for that it has to make such arrangements, right? So that it is an informed decision. Then unconditional. I can't really say that yes, you can buy product from me only if you give your consent that yes, I can send you the promotional messages. I really can't do that. So the consent has to be unconditional, right? And it has to be unambiguous. So there should not be any ambiguity, right? So it should be clear, and there should be affirmative action that yes, I am going to use your information for this and this purposes. Okay. And then notice is required to be given. So I will give the notice, and then uh, I will mention what data I will be using. What data of yours I'll be using. I'll be using your phone number. I'll be using your email ID. I'll be using what. So that also has to be mentioned. And purpose of processing. For what purpose I'm going to do that use. I'm going to send promotional or what emails. Consent can be withdrawn at any point of time. So you have given consent, you have said yes, but you can later on, after 2 days, after 2 years, after 20 years, you can come and say, don't send me the messages anymore. So you can withdraw the consent. And yes, these are some of the examples. These examples are part of the act only. Now, a very important example. So consent should not be irrelevant. So for example, food app, Zomato is having consent to your photo gallery. What it would do to your photo gallery? A radio taxi, a taxi app, Uber is seeking consent for your contact list. What it would do with your contact list? Music app seeking your location data. What it would do with your location, right? And social media app seeking access to your calendar. So these are all irrelevant consent. So consent should also be relevant to the purpose that you are going to use it for. And a very interesting example is of Google. So you use Google Maps. We use it whenever we have to go to some place, right? We put the location and then we turn on the navigation, and then we drive to that place, and then we reach. Till the time you don't reach, you are using that Google Maps. But do you know it is tracking your location all the time? Now you are opening the app, you are using it only for half an hour, 2 hours when you are driving, when you are going to reach some place. But how it is taking your data all the time, 24 hours? Because just, when this law was not there, there was no problem. But when this law came, the Google was very smart. It started sending you a new product. What was that new product? It was timeline. Where you were during the month on day 1, 2, 3, 4, 5, you went here, 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 here. So it gives you your timeline. You were in Varanasi, you were in Bangalore, or where. So basically, it has created a new product just to fall in the definition, just not to have the irrelevant consent. So it can effectively take your data all the time because of this product, right? Now, of course, next thing is very, very simple. Yeah, if there is an agreement, there's in the consent you write that yes, you cannot file any complaint to Data Protection Board, then this is not going to be a legitimate consent, only to the extent that statement is there. So other parts of it is going to be fine. It is going to be legal, but that portion is going to be not relevant. So that if you write and get the signature, even after that, that person can go to the board and make complaint against you. So there's no bar. Now, how you are going to have the consent? So it has to be, we understood it has to be specific. It has to have all those parameters. So now I am showing you our bank website. When you go on the bank website, so it show you allow cookies or manage preferences. And what are cookies? Cookies are basically your internet data, your uh, which websites you have visited, right? All those details it takes for the smoother experience, or for giving you the advertisement, relevant advertisement. Now, if you want, you can simply click on manage preferences, and then you can see on the top it is strictly necessary cookies. It is always active because it need to use that data, otherwise the app or the website is not going to be able to run. But otherwise, customer experience is unticked. Performance cookie, targeting its advertisement cookies are unticked. So you are saying, I just have to click on manage preferences. I just have to click on confirm my choices. Otherwise, if these would have been ticked already, I would have to untick this, I would have to untick this, and then confirm my choices. That means the consent, the ability to say no should be very easy. It should not be a cumbersome process. Okay, I am going to use your data. You come to my office in Delhi, you come to my office in Bangalore, give me a written letter and give the ID proof along with also, and then only I will consider it as no consent. So this is not going to be the case. So it has to be very simple. Consent giving has to be very simple. Consent not not giving of consent has to be very simple. Withdrawal of consent has to be very simple and easy. So this is a requirement of the law, right? And yes, you have to be specific when you are using the cookies, when you are using those advertisement targeting cookies. You have to mention, I am going to give it to Google for playing ads, I am going to give it to Facebook, I am going to give it to Bing, I am going to give it to LinkedIn, and this is it. So you have to be specific, how, for what purpose I am going to use your data. And then this is the example. Of course, this is internet example. And the same way, we have to include in our consent letter all those things, all those parameters, so that we cannot be challenged and taken to the board, later on taken to the appellate tribunal or the court, that we did not comply with the requirements of the law. So yes, this is very, very important. Now, what about prior to this act? So we have already our numbers shared, our email IDs are already with the people, with the companies. They are calling us on a daily basis. What would happen to that? Would they need to take our consent again? Right? So how it's going to be? So this is mentioning about that. If you have already given consent before act, then data fiduciary, the person who is having the data, need to send within reasonable time notice. And in notice, what would I tell? The personal data that I'm having your phone number, I'm having your email ID, I'm having your height data, I'm having your choices, your buying choices data, right? And the purpose for which I'm using. So this is the personal data. I am using your phone number to call you for having the loan or the credit card. And so it will tell me what is my personal data, what is the purpose for which I'm using, and then what is the right. I have the right to say no, to withdraw. It would also be mentioned on the notice. And then what also would be mentioned in the notice is that you can complain to the board also. Okay, three things. What is the personal data and purpose for which it is being used? Then I have a right to withdraw the consent. And third is I can complain also. And I will send the notice within reasonable time. Reasonable time would be mentioned in the rules. And I can keep using the data. So it is not going to hamper the businesses of the people which are running. It is just that whenever those notices come to you, your email on your email ID or your on your phone, you have to withdraw your consent if it is necessary. So yes, this thing is going to happen once the law is going to be effective, and then this consent drafting, this notice drafting is going to be a thing which the experts are going to do, of course, after reading the law, right? And then, of course, there's an example. Uh, Notice for consent versus withdrawal. So, uh, how that notice is going to be, again, it has to be in clear plain language, so you don't have to use the jargons, the tough words that people are not able to understand. And it has to be in English or any language which is specified in its schedule. There's an option to access, right? So I will give the option, okay, I am giving you this consent notice in English. You can access also this language. Just click on the link, and then you will be able to access, right? And when you click on the link, and you will be able to read in Hindi. For example, you if you pick Hindi, that yes, I can also withdraw. Then, of course, since I am understanding it, I will definitely withdraw. Okay. And then third thing is, what is the contact detail of data protection officer? That also needs to be included. And the second point is, first is right to withdraw should be there, should be mentioned. And then ease of withdrawing, so you have to keep it very very easy to withdraw. You it would just be like click on a link and withdraw. Just write back withdraw and it will be withdrawn. As simple as that. And the consequence of withdrawal shall be borne by data principal. Of course, if I have given you my phone number, my email ID, and you are sending me every month some subscription product. For example, any medicines you are sending every month, and I have withdrawn that consent. Next month, the medicine won't be coming to my home. So the consequence is mine if I withdraw the consent. I will not get the calls also, but I will not get those products also. So we have to carefully say no or yes to. Of course, yes, saying yes is not a requirement. If you don't say anything, then they are going to continue with what they are doing. But if you say no, so you have to be very careful, right? And data fiduciary within reasonable. You said no, don't use my data. Then what is the requirement? Data fiduciary, the person who is having your data, has to within reasonable time cease and cause. So basically, I will not use and I will cause the others not to use to whom I have given data. I will also take that thing from the courier company. Don't use this data now. Delete this data now. Right? So this is going to be the impact. And of course, these are the examples. And the opportunity is consent manager. So there is going to be one person who is going to send all the emails. There's going to be one person who is going to be drafting, who is going to keep the track who has sent consent, who has not sent consent, who has withdrawn, then deleting that data, sending the messages, sending the emails, sending the further communication to data processor that delete this data, don't use this data. So it is going to be a huge work. And this is going to be a requirement to have a consent manager appointed. And the person who wants to be consent manager has to be registered with the data board. So basically there is going to be a pool of the consent managers. It's going to be a registration, and then data fiduciary, if any question arises, data fiduciary is obliged to provide. So it is the obligation of data fiduciary. You can't really say I sent the consent notice, you did not receive, what would I do? So notice was given, it is the responsibility of the consent. Then of course it will be the responsibility of consent manager later on, because the data fiduciary is going to appoint consent manager. This is going to be a requirement. Okay, now is the second thing, legitimate use. How? If I don't take your consent, still I can use this information, the data. How? Number one, you have yourself provided me your phone number. You have yourself provided me your email ID. So data principal has voluntarily provided her personal data and not indicated that she does not consent to use. I have given you my data. Why I have given you? For a specific purpose. I have given you my data that yes, you deliver my laptop, phone, medicine at my home. Then if I'm using your data, your phone number for that purpose only, your address for that purpose only, then it comes in legitimate use. I don't need to take consent, because of course you understand that consent management is going to be a huge work, and primarily it is going to be done in the cases only when you are sending the promotional messages, right? Otherwise, if you are using that data for the work only, and the work, the purpose for which the data is taken, which for which it has been provided by the data principal, then it's going to be part of legitimate use. And later on, you have not said that don't use it. So not indicated that it does not consent to use. So yes, you have given your phone number because you want to get receipt of payment through a message to your phone. So, yes, in this case, of course, there's no such requirement. It is legitimate use. What is legitimate use then? For the state or any of its instrumentalities, state, government, state means central or state, any government can use your data. Why? Because for providing any subsidy, for providing any certificate service, so basically the government functioning, they can use it. And then for for these cases, of course, has given consent previously. So whenever they are going to take the data, and let me tell you, the consent previously is written here, but for state or any of its instrumentalities, it is part of the legitimate use also. It is part of the exemptions also. So yes, government can use that data. So in that case, if the government has installed the cameras, it is saving the pictures, the videos, then this law is not going to be applicable on them, right? Next is, of course, it is mentioned here, for performance by state or any instrumentalities of any function under law in the interest of sovereignty, integrity, or the security. So any of these things, government can use your data. So you really can't, you are sitting in your home, and then some policemen come and then they take you to the police station. Now you cannot say that how dare you use my address, how dare you use my phone number, how dare you use my any other personal data. Of course they are having your picture and then they are finding you. You cannot say that you are covered under DPDP Act, take my consent first. That's not possible, right? So that's why it is part of the legitimate use. So any statutory obligation, any decree, so of course court can use that information without any estoppel. So it is to have the government machinery functioning fine. Then if you have any medical emergency, then of course your data can be used. We are not going to, you're lying on your bed, we are not going to take your signature first on the consent letter. Of course, we are going to use your medical report. We are going to use your phone numbers, your email ID to contact your loved ones, right? Then in that case, this law is not going to apply. It will be basically part of the legitimate use. Any epidemic, in case of corona, for example. So there was, and of course, if and should not, it should not happen in future. But if any such situation arises, then there's a provision that yes, it would form part of legitimate use. You can't, if someone picks you up from your home and takes to the hospital, which happened in the first phase of the corona, then you can't say basically you have not taken my consent. How can you use my health record? How can you use my address to you're taking me to hospital? So basically, yes, public, anything for public order, any for employment. Now it is very important. If I am taking your data, your phone number, your email ID, your address, your Aadhaar card, a lot of your details, because we take from employees, right? And of course, I'm working with RBS and they have taken all these information. In that case, this is part of legitimate use. They don't need to take my consent, additional consent that yes, we are going to use this information. They, for employment purpose, just to keep the ease of employing someone and to have lesser disputes, then it is included in the legitimate use, right? Okay, so there are two things that we have understood. Consent. In the consent, we have understood, okay, what would happen if there's data and it is being used prior to the act, then notice is going to be given. Then we have understood what is consent manager, and then we have understood what is legitimate use. Now, this is very important. What is the obligation of data fiduciary? What are the liabilities which are put on the data fiduciary? And you will be surprised, every liability is on data fiduciary. Only 99% of the uh, penalties are on data fiduciary. Now, what it has to do? It has to comply provision of act or rule. So basically, every provision, every section, it has to comply. So this whole law, he or she has to comply. And second is, can appoint a data processor. Yes, I can take help of any courier company. I can take help of uh, uh, any calling company. So basically, I can appoint a data processor that yes, use the data, use the phone number, use any information that I have collected on my behalf. And this is going to actually change few things, because since we the responsibility is going to be on data fiduciary, I am going to be responsible for everything, then I am not going to give my work to someone who is not capable of handling that data. Basically, the work, so this is a prediction, of course, this is going to, or it can go otherwise also. So one thing is, I am responsible for keeping the data protected. I would definitely want to hire a courier company who is reliable, who don't part with my data. I will not hire a new courier company who is small, right? At the same time, when I'm saying this, there can be inverse situation also. I am hiring a small company just because the law is not applicable on smaller ones now. So yes, there are going to be different things. But yes, we are going to see. And then what else? The decision that affect the data principle. If I am taking any decision on the basis of your data, for example, I am a school and I have taken your child's uh, marks, basically marks in different subjects. You want to take admission in class 6, and from class 5 I've taken the marks, and you have given all the marks. For example, he or she scored 90%, and instead of 90% I just mentioned 60. Now the merit list comes and your child is not able to take the admission. Why? Because you provided 90, they entered 60, and that's why they were not your you could not have your child admitted there. Admission could not happen, right? In that case, it is the responsibility of the data fiduciary, the person who is saving the data. It is their responsibility to save the correct information. The completeness, accuracy, and consistency is also going to be my responsibility if I am going to make any decision on the basis of that data, right? And then technical and organizational measures. I will have to have the encryption system so that no one takes the data from my computer through online offline any mode, right? I will have to keep the file secure. If of course the files are not part of this act, but yes, we will discuss how it is going to be covered. I will have to keep the antivirus. I will have to have those pen drive accesses stopped. So we are going to discuss how we are going to do that. So it is my responsibility that data does not go anywhere else, right? And for that, I will have to take all the measures. Then security safeguard to prevent personal data breach. Again, it is the same thing. So yes, the last point I have discussed first. The fourth point is technical organizational measures for the compliance of that. So basically, what I have to do, I have to create a team. I'll have to hire people. I'll have to hire consent manager. I'll have to hire a data protection officer. Of course, this is going to be my responsibility, or I'll have to hire a consultant so that this act can be given effect to. So yes, I will have to take all the organizational measures, all the technical measures which are required to give effect to this data protection law, because it is going to be my responsibility. Whose responsibility is going to be? Data fiduciary. So you can see every responsibility in the act is for the data fiduciary only. And then it has to tell board and each affected data principal that yes, I have done a breach. For example, I sent a wrong file, an Excel, where all the details, your bank statement or your phone number, email ID was there, and instead of sending it to you, I have sent it to someone else. Then I have to tell that okay, there has been a breach. I have by mistake done this data breach. I have I have to tell to the board also, I have to tell to the data principal also that your data is what I have compromised. This is also an obligation of data fiduciary. Then erase personal data and cause data processor to erase. I have said, okay, don't use my data now. So it is going to be the responsibility of data fiduciary, erase that data and cause that other person, data processor also to erase. And so seeing this, you can understand there's going to be a lot of focus on having the right type of contracts with the data processors. So this is another area where we can pitch in and we can give the right wordings, right clauses to include. Uh, so because ultimately the responsibility is going to be data fiduciary, right? And I have to protect myself. I want that person to erase the data. What if that person does not erase? So there has to be a proper agreement. There has to be a proper contract with the use of which I can actually cause it to erase, right? Now, if the sale is concluded, why shall no longer retailer personal data? Of course, the purpose for which the data was used was taken. Once the purpose is over, you have to really say, okay, now you have to erase. And this is a smart thing also, because when you erase data, then it is going to be lesser of your responsibility because you have already erased that data. Now, less data means less obligation, less responsibility, less chances of accidental disclosure, right? And then, but yes, of course, there are certain organizations where you have to maintain the data. Bank have to maintain 10 years data. Of course, we are also having the professional ethics where we have to maintain the data. Income tax is also its guidelines. So even then, even when the work is over, you need to maintain such some data as per some of the regulations, some law that is going to stay, right? Okay. Now, data breach. If you give data to someone, any unauthorized processing, if someone has used that data or accidental disclosure you have done, you have shared, you have done alteration, or you have loss of access. So basically anything you have done to data, you have altered it or you have shared it with someone, then it is going to be your responsibility, and it is written even accidental disclosure. So it does not matter that you did it for some gain, some you have sold the data, you have by mistake sent the data, even then you are going to be uh, booked under this law. And there is no exception whether there is a cyber attack or a hack. So you can't really say, okay, I have my computer, I have my data system, but someone hacked my computer, there was a ransomware or something like that. You can't really say that, because it is your responsibility to have all those encryptions, all those training to the staff so that they don't click on these phishing links. So this is your responsibility, and the people who are working in the corporates, they can vouch for it. They get regular trainings, they get regular emails about phishing and all, and some companies, including mine, and they send the phishing emails. They send those fake emails, they give links in that, and they see whether you click on those links or not, or whether you report those emails. So there is a culture that they are making, because it is going to be the company's responsibility, not, you can't really say, okay, my employee clicked on some phishing link. Then I would ask you, have you provided the trainings? Are you taking all these measures? You are sending the phishing emails, fake phishing emails to test whether your employee clicks or not. So these are going to be my responsibilities only, right? Okay. Now, how to keep the data secure? So we have understood, yes, there's data, there's personal data, there are certain parties who are using this data, and then there are ways in which I can use that information or data. Now, and we have also understood that yes, there are a lot of obligations, there are a lot of penalties we are going to see, but yes, there are a lot of obligations on the companies, on the data fiduciary. Now, how to keep the data secure? So in our offices also, we are having a lot of information, client data, client information. How can we keep that secure? First of all, you the policies that we see in the bank, so we basically have to apply those things to our offices also. First of all, there should be a habit of uh, creating passwords which should be cultivated, and there should be a strong password security, and those things, one numerical and then alphabets, 8 9 letters, and some special signs, so all those things, right? And of course, there should be habit which should be cultivated, that whenever you are going from your desk, you should lock your system, right? And of course, many professionals have their offices where someone enters and then he can see left, right, everywhere. The computer screens open, and then he can actually take any data from there, right? So yes, we have to make those kind of arrangements also, so that people are not having those excesses. Then protection from physical theft. Protection from physical theft. So computer, memory card, pen drive. So someone inputs pen drive and then takes the data in the pen drive. So it is going to be your responsibility to block the pen drive access, to block the memory card access. And so what our organization has done is, so of course they are part of the DPA or GDPR. They have to comply that. So these things happened way before in our organizations. So they are having computer, they are having CPUs, and of course the data is, first thing, it is saved centrally. So say data is not saved in the computers. Number one. Second thing is, even if some data is saved on some download section, document section on your personal desktop, to protect that data also, so they are not having screws in the CPUs, right? Because in CPU there's a hard drive. So in the CPU box, they are using some tags, and what that tag is, so if you are going to cut that tag, mm, it is going to be caught. So screw, it is very easy, because you unscrew that screw and then you take out the hard drive, you copy the data, you again put that hard drive back, or you steal that hard drive, whatever. But in this case, when you are opening that CPU box, it is going to be caught easily, right? So yes, these are the measures. And then of course, central encrypted drive, you should store your data and you should include disclaimer in your email. So this is the disclaimer that you should include in your email if the message, because it is a possibility that you send email to someone while you were to send the email to someone else. So accidental disclosure is very much possible. So what you have to do is you have to include this. If the message is received by anyone other than addressee, then tell me. Please return the email by replying, because I will have to do what? Disclosure to the board and to the data fiduciary that we read, right? And then delete the message. So these are the safeguards that we have included. That person might not reply, that person might not delete, but these are some of the measures which are going to get the penalties lower. And we are going to discuss in the penalty section how it's going to be there. So these are the kind of advices that as consultants that we have to do, we have to make, and then we have to implement also in our offices. And of course, forward emails only on need to know basis, or share the data only on need to know basis if that party, that article is not concerned with that party, for example. Then don't share the information of that party with that article. So basically, need to know basis, you need to keep the information accessible to few people only who need it. Simple. And then that's how the data is going to be protected and secure. All right, now significant data fiduciary. Who is SDF? Who is significant data fiduciary? Basically, this is the person, this is the client, this is the party who is significant, who is big enough, right? So the name suggests you are having such huge volume of data. You are having a lot of data. You are an IT company, you are Google, you are Facebook. If your data is disclosed, then, or if there is a cyber attack on your website, then it is going to be, you're going to share 1 crore people's phone number. So the impact is huge. So significant data fiduciary are the big people, big companies who are having a lot of data, or the sensitivity of data. You are a hospital, you are an insurance company, basically you are doing all the tests, right? And then you are having people's health information, who is having diabetes, or who is having, because you really don't want to disclose that yes, you are having this disease, right? So that's why, if there is any sensitivity of data, banks, insurance companies, yes, these in bank you are having your wealth information, chartered accountants, even, of course there is a sensitivity of personal data. You are carrying all the sensitive information, right? And then risk to the right of data principle, or there is a sovereignty integrity impact. You are a media house, basically you are keeping a lot of information, you are shooting videos of the people who are victim of various crimes. So basically you are having a huge impact. You are having, so you are election commission, for example, or the private bodies equivalent to that. You are having such data which can have an impact on sovereignty integrity. You are Twitter. So these people, sensitive data, volume of data, where there are risks to right of data principle, sovereignty integrity, the impact, risk to electoral democracy, public order. So all these organizations are SDF, and these are going to be the first organizations, first set of people on whom this law is going to be applicable, right? So all the big companies. And this SDF has a requirement that yes, it need to appoint the data protection officer. He is going to be, so it is just like a compliance officer. So you had the compliance officer for various company law compliances. Now this data protection officer is going to be solely for the data law compliance. And this data protection officer needs to be based in India. He should be an individual. So there should be a person whom you can call, whom you can summon, whom you can ask questions. It's not like you have given some contract to some company, some firm, and then a firm has 1,000 contracts, 1,000 parties, and they are not responding. So there should be one company, one data protection officer. who is dedicated for this work only. Okay. And then what else it has to do? It has to appoint independent auditor to do the data audit. Okay. Data audit is a thing which it has to do. It's a new thing, right? Data protection impact assessment. It has to do data protection impact assessment also. What is that? Basically, and this is going to be the thing that the companies are going to do when this law is going to be applicable. And some companies have started even now also, right? The companies who are going to be impacted, they have started the work already from 2023. So what you have to do is basically you have to see what data I have. So first of all, you need to understand I am having this data. You have to do the classification. Okay, this data is sensitive. This data is non-sensitive. This data is having this data is covered under data definition. Personal data. Uh, you are having personal data also. You are having non-personal. So you have to do all those segregations. Then you have to understand what is the impact. If the email ID is disclosed, what is the impact? If the health information is disclosed, if the password is disclosed, so you'll have to make those impact analysis, impact assessment, and it is going to be of course. And then you have to, if your current framework is not efficient or sufficient, or your framework is not fitting, or there is no framework, basically you have to put that framework in. You have to uh, form a procedure of everything. So these are going to be the things that these SDFs and everyone, every firm, every company on which this law is going to be applicable, they have to do it, right? Okay, now data principle, we have discussed all the law, and we have discussed it because it is applicable on the data fiduciary. And why this law is made, because data principle is there, we have to protect its rights, right? Now what are those rights which we are protecting? So of course one is of course that harassment or that calling, those inconveniences should not happen. But yes, there are certain rights also explicitly given to data principle. So those inconveniences we have curbed, we have given a lot of obligations on data fiduciary that is being taken care. Now, data principle has certain rights. I can really ask data fiduciary that yes, give me summary, what personal data you have. It has given a notice in the beginning, but I can ask whenever I want, okay, give me the summary, whatever data you have for me. And also give me the identity of all the data processor, all the person, all the companies, all other data fiduciaries to whom you have given my data. So I will have to tell, okay, this courier company, this phone company, this, uh, I have given your data, right? And then any other information which you want to know about your data, you can really ask. And then I have a right to correct. Okay, I will get the data from you. Okay, this is the summary of the data. This is this data I have. This is the whole of the data. And then this data is wrong. You correct my data. I have a right to ask correction. I have a right to ask erasure. Okay, you are having 7 items. You erase 6. Have only one, my phone number. That's it. And then right to grievance redressal and later on approach the board. What is this? I have a right that you listen to my grievance, you listen to my problem. I am getting a lot of calls. You resolve it, you listen to me, and later on approach the board. So I really can't go to the data protection board and file a complaint against you. I first have to tell you that yes, I am having a problem with with the data that you have shared with your data processors. I'm getting these calls. Resolve it. If he is not able to resolve, if he does not resolve, then you can go to data protection. Or he is not correcting your data, is not erasing your data, then you can approach the board. And there are some duties also. And there is a small, very small penalty also. We'll discuss that. And what is that duty? Not to impersonate. So you don't have to impersonate data. So basically, you can't really say I am a doctor. You can't really say Dr. Harpreet Singh. You are not a doctor, right? You are impersonating data. You are trying to be someone else. you are writing your name as Manpreet Singh. You are not Manpreet, right? So you can't really impersonate. You have to give the right information. You not to suppress any material information. So you don't have to hide. For example, I am going there for admission. I should not hide that yes, I have a jump year. I have taken a gap in my education. So don't you have this is just an example, right? You don't have to suppress any material information, and then you don't have to make a false compliance. Only verifiable authentic information you have to provide. So yes, it is the duty, only duty of data principal is this in this whole law. Rest is the duty of data fiduciary, data processor. That's it. Okay, now there are certain exemptions which we have. For what is that? First is, of course, you can enforce any legal right or claim. So uh, you are going to the court, or you have any legal right you under the contract of tenant and the landlord. So the landlord can use your information, your phone number, your address to get his rent. You fly away and then you are not paying his rent, then of course he can come to your address. He can use that address to come to you to file complaint and anything. So to enforce any legal right or claim, you can use that, whether it is through the court or not through the court. Then performance of any judicial or quasi judicial function. So any court tribunal, they can also use the data. And then in interest of prevention, detection, investigation, or prosecution of any offense. Like I said, you can't really say that how dare you use my information, my address details, and come here and you are picking me up and taking to the police station. You can't really say that. You are arresting me. You can't really say that because it is part of the exemption. It is again part of the legitimate use also. So yes, there is a reasonable protection of these functions from DPDP purview. Okay. Then protection of data principal outside. Now, this is a very, very interesting exemption. I've told you that the data that you are using here in India. So you're calling someone in India, right? From India. Then this law is going to be applicable. Now, you are calling someone from outside India, but the person is in India. The person is an Indian. Then also this law is going to be applicable. Now, what this exemption says is you are in India and you make an agreement to some foreign entity. So I am here. I'm working in, for example, Infosys. I do an Infosys runs a call center, for example, and what I am doing is I am calling on behalf of Infosys to the people who are in UK. So the data principal is not in India, right? This is phone number of a UK person. The company is also UK based, so data fiduciary is also in UK. Data fiduciary is in UK. Data principal is in UK. I am just processing the data. Then the current law, the DPDP Act, should not be applicable on me because what law would be applicable on me? Their GDPR. So this is the exemption if processing of data principal outside. So data principal is outside India pursuant to any contract entered with any person outside the territory. So I have my contract with any person, Infosys outside India by any person based in India. Then this law is not going to be applicable. Then in that case, their law is going to be applicable. That's why there should not be double compliances. So that's why it has to be exempted. And then, of course, processing necessary for a merger, amalgamation, or similar arrangement, which is approved by court or authority competent. So whenever there's a merger which happens, your employee becomes their employees, and then, of course, they are part of that employment agreement again. And then, of course, there are your client become their client. So yes, in that case, you can use all the data. So these are exempt. right? So you don't have to again take all those consents and all. So this is for the purpose of keeping that amalgamation easy. Now, exemptions, the same exemptions are mentioned here. There's very important, before central government, before expiry of 5 years from the date of commencement of the act, by notification, declare any provision of the act shall not apply to such data fiduciary or class of data fiduciary. Now, this shows the intention of the government, and the same happened outside India also in the Western countries, because it's a big law. It's a law which is having a huge impact. Then, of course, this is not going to be applicable from day one to all the people. Of course, there's going to be time frame. It is going to be applicable in the stages, and the time frame is 5 years, and that's why it is mentioned here. Government can notify, okay, till the 5 years these are exempted, these are exempted, now these are exempted, the same way India has got applied, right? So yes, of course, whenever something is applied, then it is going to be in a phased manner. So this is an exemption. Exemption to state instrumentality, that same thing is mentioned here. For research, archiving, or statistical purpose, for any AI, of course, there's a debate whether AI is included in this or not. So yes, that is also going to be research, archiving, or statistical purpose is also going to be exempt. Then fiduciary, in some fiduciary including startup. Now 5 year condition is not mentioned here. So if the government want to exempt some small companies, government want to exempt some small businesses, government want to exempt some startups, then of course it can do. And it is mentioned in the exemptions. Now, miscellaneous provision. So, government through notification may restrict transfer of personal data to such other territory or countries outside India. So, yes, when we were seeing those huge penalties, so there was one penalty where the data was being transferred from Europe to US, because these IT companies are in US. Then there was some anomaly in the transfer, and then the penalty was levied. So in this case also it is mentioned that yes, you can restrict transfer of the personal data. And then there are provisions for data protection board, appellate tribunal, dispute resolution, voluntary undertaking. Now, what is DP board, data protection board? So it is going to be a board to who is going to oversee the implementation of this law, who is going to see what if there are any anomalies, if there are any non-compliances, then it is going to listen to all those cases and give the verdict and all. And how it is going to be structured, it is going to have a chairman, and it is going to have members who are having special knowledge or practical experience in the field of data governance, admin. So basically this is the structure. And very important, this is going to be a digital office by design. So basically you are going to have an online office. You can represent your client online, and it is going to be digital by design. So basically right now in income tax, like we are having faceless assessments, the same way it is going to be here only. And that's why there's a good scope, because you can represent your client from anywhere, right? And then it will not take into custody any equipment or any item. So there are various laws in which they seize your uh, instruments, they seize your computers, they seize your office. It cannot be done in this law, so that that working is not hampered. But yes, they will put some restrictions, etc. Now, appellate tribunal. So you are not satisfied with, you can complain to the data protection board, and you will have then representations, and then DP board will decide the case, will impose penalty. If you are not satisfied, then you can go to appellate tribunal, and then within 60 days of such decision you can go, and that has to be disposed of within 6 months. Otherwise, appellate tribunal has to record the reason. So this is a basic framework of the data protection board, right? And of course, there are certain amendments to other law. Of course, try act in appellate tribunal, because we are using that appellate tribunal, telecom regulatory appellate tribunal, is going to be the DP appellate tribunal, right? So there is a change in that act. and Information Technology Act also, compensation for failing to protect sensitive personal data. So earlier there was a provision for giving compensation if you are disclosing some, because it was sensitive data only, right? It was your password, it was your sensitive health records. But in this case, this is now omitted, this is now removed, and the only law is the DP Act, right? And Section 81 also amended, Section 87 also amended. So there are certain definitions which are mentioned here. So these are actually removed because now these are part of the Data Protection Act, right? Now, Section 81J of RTI Act also is substituted. So in RTI, you could get the information on the you can just write to the government, and if it does not include any personal data of some persons, you have the right to get it from the government. Now, this section is removed. So yes, there has been a lot of debate whether the RTI is going to be that powerful after this omission or not. So yes, there's a debate which is going around on this. Now, very, very important, the penalties. So penalty, and let me show you what are the penalties. So first penalty is you're not having security safeguard, you are not following your obligations. There is a issue, data breach, which is relating to the children. Then of course, you are going to be penalized significant data fiduciary. There are penalties, voluntary undertaking related penalties, and then any other provisions. And what are the penalties? It is 250 crore, 200 crore, 250 crore, right? This is the maximum penalty. And in the end, it is written cannot be increased to more than twice. So yes, you can do 250 to 500 crores. The government, if you want, it can change it to 500 crore by way of rules, but yes, not more than that. So yes, there is an upper cap also, but I'm trying to show you how huge these penalties are, right? So yes, this is going to be very, very huge, and the smallest penalty is 10,000. This is 10,000. And breach in observance of duties under section 15. And who is that? That person who is doing breach is the data principal. So the only penalty on data principal is maximum 10,000. So the penalty is for the data fiduciary only. So this law is going to have a lot of obligations, a lot of penalties on data fiduciary. And for a small issue, for a small breach, is it going to be 250 crores? Of course, we know the answer is not yes. Why? How the penalties are going to be determined? So that is also mentioned in the law, that penalty section 33 provide when the board determine on the conclusion of inquiry that breach is done, rule is not being followed, and that breach is significant, then of course it will provide opportunity of being heard. That is very normal, and impose penalty which is specified in the schedule. But yes, what are those factors which it would take into account while implementing the penalty, while imposing the penalty? It is the nature, gravity, and duration of breach. You are doing that breach from last 7 years. You are calling people from last 7 years. So the duration of the without the consent. So what is the duration of breach? That will also be taken into consideration. What is the gravity? You are using people's password, or you are calling them, or you are silently sending a message. So what is the gravity of the situation? What are you doing? Are you actually harassing people, calling them 20 times a day with different phone numbers, or you're just calling once in a month? And so what is the gravity of the situation, what you're doing? What is the nature of the breach? You're calling them, or you're selling them some travel packages, or you're selling them some fake products, fake beauty products, for example. So what is the nature of the data breach using that data, right? Is there a repetitive nature? Okay, earlier you were also doing the breach, you were penalized, and then again you are doing the same breach, third time, fourth time. then of course this shows that you are not taking the penalty or the law seriously. Then of course the penalty is going to be huge. Next is gain or avoided any loss. So whatever gain you have made, so what you have done is you have sold that data for 4 crores. So that gain is going to be your penalty. The basis is going to be the gain. So 4 plus 1 crore, maybe 5 crores, or this is going to be the penalty. Or avoided any loss. You have used that data to avoid any loss that you could have. Then also it's going to be taken into consideration, or whether personnel took any action to mitigate the effect. Okay, there was a data breach, there was a malware attack, or your data got accidentally disclosed. So whether the company has employed uh, any kind of encryptions, or it has disclosed this to the board. So these are the kind of things that are going to be seen while imposing the penalty. And very important, whether penalty is proportionate and effective. You're a big company, your revenue is 30,000 crores. I implement a penalty of 1 crore on you. You are not worried at all. You are earning 3,000, 4,000 crores in a year. So basically, you're not worried at all. Then I will have to impose the penalty which is effective on you. Don't need to see what is the gain. Don't need to see whether it is repetitive. Don't need to see what mitigation you have done. The penalty has to be effective. And of course, there's no one criteria which is going to be the only criteria, because all of these are taken into consideration while the penalty is being imposed on you. And of course, it is going to be part of the Consolidated Fund of India. And yes, this is written here. Now there are certain issues and challenges. Of course, there are huge penalties, and then publicly shared personal data is not covered. Then of course it is a thing which is going to happen, because there are a lot of social media AI tools and the profiles are public. So yes, these are some of the challenges, but yes, some things we have to accept. Overall cost push for the industry, we have seen that yes, data fiduciary has a lot of cost which is going to come. SDF are going to appoint the data protection officer, and they are going to have data audit, impact analysis, impact assessment, and then they have to appoint consent manager also. They have to maintain the all the organizational measures, people, teams, and they have to have all those encryptions, those antivirus, all physical protections to the data centers. So all these things are going to push the cost of the industry, and that is one of the reasons why this law is being deferred. But yes, no more. Of course, it is part of 100-day agenda of the government. Impact on AI tools, because AI is artificial intelligence and it uses a lot of data to train itself and be better. And when there are data protection laws, there is a data, uh, you can't really freely use the data, then there's going to be a challenge. Now this is going to be the impact of new law. Yes, of course, we have to from day one we have to examine the applicability, non-applicability. It is applicable on my client or not, uh, and what is going to be the non-applicability. Or legal documentation you have to be done complying with the new law, your contracts, agreements, your consents, everything. And then you have to review your existing model, your data of employee, customer, what all data you have. You have to request consent, and then withdrawal of consent. You have also to keep in mind impact assessment you have to do, and then cyber security system. So everything basically is going to be happening that we have discussed. Now contribution by chartered accountants. We are auditing the sensitive industries, banks, health insurance companies, hospitals, IT, other industries. So these are very sensitive industry. And of course, we are doing certifications also in banks. So there might be a new certification which is part of the statutory audit, which can be related to Data Protection Act compliance. And then, of course, initial impact assessment. we have to do, what is the data, what is the type, what are the consequence, internal control procedure we have to design, data audit we have to do, notice for consent we have to draft, withdrawal of consent of course we can manage, working as a consent manager is possible, data protection officer of course you can be, because it involves representing your client, your employer, representing client before DP board and appellate board, compliance of the law. Of course, these are the contribution by chartered accountants. And yes, these are the non-digital data privacy evasion. So yes, if the data is non-digital, you are keeping in your files what all laws are applicable. Of course, the constitution protects it right to privacy. DPDP is not applicable. Yes, that's true. So one way is you can keep your data in your files, but yes, these laws are definitely applicable. Indian Penal Code, there are some voyeurism, stalking, and disclosure of identity of victim of certain offenses. CRPC, CPC, Indian Evidence Act. So these are having certain sections which are still there. So yes, GDPR and DPDP, there's a uh, differentiation between these, because DPDP is GDPR is ultimately the parent law for all these laws. So basically, then this is going to be there's going to be a comparison which is very obvious. Only one comparison I will cover. Just we are almost done. So the second last is the data controller and data processor are required to maintain record of processing activity. And now what is record of processing activity? When I'm using the data, for what purpose I am using the data. So you have to maintain, today I have called, tomorrow I have called, day after. So you have to maintain all the data regarding the use of that information, which is not thankfully in the DPDP, because ultimately then you have to install a different system altogether which track all these details. So it's a big savior, I would say, right? So yes, this was all from my side. Any questions, I'll be happy to answer. Yeah.
Thank you so much, sir, for the wonderful session. We have some questions from our participants. I would like to read them that for you. First one from V. Subramanya Iyer. Sir, I believe I am honor of data principal on a recent visit abroad. I had to undergo medical test as per direction of local doctor. After test, necessary treatment was provided, but the clinic or hospital refused to hand over digital or hard copy, which was not given to me despite a repeated request for sharing with my doctor in India. The clinic is saying that as per the policy, the test result will not be shared with foreign visitors, and I have to pay registration charge again if I have to get test result of first visit. Is the stand of the clinic located in Canada is justified?
Okay.
Okay.
So
So
I can hear
I
my
can hear my
voice.
voice.
I don't know.
Sorry.
Sorry, I
Sorry,
am
I am
actually
actually
hearing my
hearing
voice
my
back.
voice back.
I don't know.
I don't know.
One second.
One second.
Let me
Let me
stop
stop.
this. Okay.
Okay.
I don't know.
I don't know.
I'm hearing
I'm
my
hearing
voice,
my
but
voice,
yes,
but yes,
let me
let me
answer
answer
sir's
sir's
question. So,
question.
sir,
So, sir,
you have
you have
asked
asked
basically,
basically,
you have
you have.
done some tests with the Canada-based um, testing agency or hospital, and now they are not giving you your data, basically. So, since first of all, since this DPDP Act is not applicable, so yes, till this time, there's a gap. Secondly, since it is in Canada, we'll have to see what those laws are. Again, since if it is DPDP, since you are a person who is Indian, right, and they are using your data, then DPDP is there, and then we can actually uh, talk to them regarding the grievance. But yes, till the time we'll have to rely on the Canadian law, and in Information Technology Act also does not actually provide any remedy relating to this. So and nothing is mentioned about this. So the IT Act right now provides is the disclosure. They are stopping the disclosure. They are not actually talking about data ownership, right? DPDP Act is talking about data ownership. So till the time we'll have to rely on the Canadian law, and we'll have to see the it on the case to case basis. So you can contact me maybe after this call. My number I showed on the screen. Yeah.
So thank you so much, sir. I hope Subramaniam sir query has been resolved, or it will be get resolved after the seminar. Okay. Second one from Sakshi Kapoor Arora. She's asking, putting a disclaimer in emails may be helpful in keeping the sender safe or to reduce the overall penalty, but it may be a route to share the data to unauthorized person and pleading not guilty.
No, no, no,
No, no,
ma'am.
no, ma'am.
It's
It's
okay. I'm
okay. I'm
hearing my
hearing
voice
my
back.
voice back.
Okay, so
Okay,
it's
so
not
it's
like
not
that,
like
ma'am.
that, ma'am.
Basically,
Basically, that is
that
that
disclaimer is
disclaimer
not
is
going to
not going
save
to
you
save
in
you.
any way, but that is going to there's going to be a chance that you get the data deleted, big, or you get intimation back that yes, you have disclosed it accidentally. So, for example, I have sent in email a wrong attachment. So, if you are replying me back, I will get to know that okay, I have sent it to the wrong person. Probably, if you don't reply back to me, I would not know at all for years and years that I have sent you wrongly. It happens, right? Someone says, okay, I have not received. Then what we do is we send again. We don't see that, okay, we sent it, but how this person has not received. So it is not basis for pleading guilty. It is just for the protection of your own. Law is not saying at all to include this disclaimer. This is some advice from my side only. So law is at no place saying, law is very, very strict. It is saying even there is accidental disclosure, even there is cyber attack, you are not getting any ground for pleading guilty. You are on mute, ma'am.
So another question from Preeti. Cameras, we have cameras in office. So whether these cameras covered in DP Act or not?
Okay,
Okay.
you can
You
put
can put
yourself on
yourself
mute.
on mute.
Ma'am, you can put your yeah. So when you are unmute, I hear my voice back somehow. I don't know. Okay. So the thing is, ma'am, yes, one thing is you are using it for your personal purposes. Since it is installed in your office, it is definitely part of your DPDP Act. It is going to be part of that. So it is your responsibility that you keep it safe and you do not disclose it to some other purpose. Of course, what would you do with that? You are not putting on YouTube, you are not putting on Facebook. Then this is not going to harm you in any way. The only thing you have to do is you to keep that information secure. It should not be disclosed anywhere. But yes, to answer your question, yes, you are going to be part of it since you are using it for commercial purpose. And
And the extent of
the extent of commercial purpose is what you have to determine. It is somewhere in between commercial and uh, personal. Full commercial would be if you sell that information, if you sell that video, but you are not doing that. So there's not going to be much of an obligation. There's not going to be those consent kind of things coming for you.
we have these much questions with us. So right now we are in the process of closing the session. So before that, we have one more question, sir. From Mayur Mohanji, sir, will this law be applicable even to central, state, and local government departments? And where we obtain statutory registrations like GST, income tax, etc.
Okay.
Okay.
Yeah.
Yeah.
You can put
You can put
yourself on
yourself
mute now.
on.
Ma'am, you can put yours. Yeah, perfect. So yes, it is not going to be applicable on these departments. Why? Because it is these are part of one legitimate use also, and second the exemptions also. So if if they are using any data for state or any of its instrumentalities for public order for issuing certificates, so yes, these are part of exemptions, sir, and are not going to be these entities, the state government, central government, local authority, are not going to be part of DPDP Act.
So we have these much questions with us. So um, as we conclude our today's insightful and enriching webinar, it is my privilege to extend our heartfelt gratitude to all those who made this event possible. So, firstly, I would like to express our deep appreciation to our esteemed speaker, CA Harpreet Singh, for sharing his invaluable knowledge and expertise. Sir, your insights into the Data Protection Act have been profoundly enlightening, and thank you so much, sir, for taking the time to engage with us and for your compelling presentation. And I would also like to thank our organizers and the entire team behind the scenes. Your hard work and dedication ensure the seamless execution of this webinar. And our sincere thanks to all the participants for your active engagement and thoughtful questions. Your presence and involvement are what truly made this webinar interactive and productive. So, and lastly, we extend our gratitude to the technical support team for ensuring a smooth and glitch-free experience. And thank you all once again for your time and contribution. We look forward to your continued participation in future events. Have a great day. Thank you.
Thank you, ma'am.
Thank you.